All right, so up next we have Jeff Yungman and Mary Vosburgh from 180 Justice Place, or
180 Place.
180 Place.
Homeless
Sorry,
Justice
they
Project.
just changed their name, so there we go. Sorry, yes, thank you. So they're out of Charleston, and they were very kind to come up and present on child support, which is another really popular area in our clinic, and a lot of people get really nervous about child support modifications, but they're going to make it sound so simple and easy and wonderful that you guys are going to be begging to do child support cases, and we're going to love you for it. So I'll hand it over to them.
All right. Thank you, Ashley. Mary and I are employed by 180 Place, which used to be called Crisis Ministries, and as far as we know, 180 Place is the only homeless shelter in the country that has 2 lawyers full-time working there to provide legal services. Mary's been with us almost 3 years. I've been with 180 Place for 17 years in July, but only 9 of those as an attorney, 8 as a social worker, and I went back to law school with this gentleman right here. And got my degree in 2007, actually, this month. We do ours a little different. We have legal clinic twice a week, 2 afternoons, Tuesday and Wednesday afternoon, and we let people just come to us because we like to be surprised at what's going on. We don't need to know ahead of time. So they just come to us. We deal with their legal issue, represent them, or advise them, whatever it is. Last year, I think we had 613 clients that came through the program. About half of those clients were veterans. I think 51% last year. It fluctuates from year to year. We don't do it ourselves. We have law students that help us. We have other lawyers that help us. We couldn't do 600 folks ourselves.
And we have a legal assistant. We have a paralegal.
Oh, we do have a paralegal, yes. That we always try to get to come to these things, and she never wants to travel. So, okay. This just tells you that there says 3 unmet legal needs issues for homeless veterans. Child support is one of those 3. For our program, I think child support comes in 2 after veterans benefits. It's veterans benefits, Social Security benefits, that issue. And then child support is the next thing the veterans come to us about, almost exclusively. The Department of Health and Human Services is the federal agency that runs the Child Support Office of Child Support Enforcement. It covers 4 different areas. We're only going to talk about numbers 2 and 3, and 2 just briefly, to touch on paternity, but we're just going to talk about establishing, enforcing, modifying supported allegations. Locally, child support is a part of the Department of Social Services. It's known now as Integrated Child Support Services. Federal statutes is what control the program, but policies and practices change from state to state. So some of the things we'll tell you that's done in Charleston County may not apply to Richland County. It really depends, and Mary and I were talking about this, depends on the relationship you develop with the folks at the Child Support Office. We've got a pretty good relationship with them, and we can get things done that probably certain parts, the other part of the state, I don't know about Richland, that probably can't get those things done.
I'll say we have sort of developed, we're working on developing a pretty good relationship with our local DSS. There's one particular attorney who's available on standby today at the clinic to answer questions if she is available at that moment. So you just email her, and she's super good at just emailing back. So if you need to know when a hearing's coming up or what the status is of somebody's case, you can just email her. She's been really great so far. So hopefully we'll expand that to have more attorneys at DSS involved.
We gave you one of ours, and she quit and went to the public defender's office.
Oh, is she?
Yeah, in Lexington County.
Yeah.
Right. As far as paternity goes, there's 4 different ways paternity being established. Bring this up primarily for the 4th reason. We've had at least 2 cases I can think of where we had pretty good proof that the person was not the father of the child, but because they started paying child support, they are considered the father of the child and have to continue to pay child support. We tried to go to court to get it changed, but the judge just not would listen to us. That once they started paying child support, that's acknowledgement that they had paternity for the child.
Yeah. Well, maybe they'll change, along the way, but in those cases, or in that case, they wouldn't, they said it was acknowledgement of paternity.
Yeah, it was Judge Martin too, who's
Yeah.
pretty
Pretty lenient.
lenient, yeah.
Mhm.
So what do you suggest, they ever pay child support until they get a paternity test?
The paternity's issue, get a
If
genetic
it's,
test.
yes. if it's that issue, if you have a person come to you and says, there's this child that was just born or that's this old and, I'm being told I'm the father and they don't have a court order against them at this point for child support, then yes, I would do a paternity test. Before the mother goes to DSS or somewhere and gets a child support order. And when DSS is approached to institute a child support order, they will do a paternity test. They will want to do that first, if there hasn't already been paternity. So, but yeah, if it's early enough, I would clear the air before. I mean, and unfortunately, you're going to find people that are going to want to do the right thing, which is great. They're going to want to start paying that support if they think it's their child. But then, unfortunately, the court has found that, payment of child support is acknowledgement. Now, I mean, that's not, as far as we know, I don't know if that's a law, if that's like really ingrained in our case law, but that's how it's happened, so.
Obviously, the mother has some indication that possibly.
Well, the one
mother's
case,
not
yeah,
always nice.
in the one case we had, the mother actually had passed away, and the child was living with the grandmother, and at that point, he found out that he was not the father, but.
Yes.
In a situation where a father believes that it's his child and he wants to get a paternity test, is there any way to force the paternity test? Because there typically we find that there's problems with the mother cooperating with the father.
Is it through
DS.
DSS, is the
Well,
child support?
it's kind of prior to a situation where they're threatening going into a command situation, somebody's chain of command versus, pay with this child support. He just wants to initiate the paternity test, kind of hey, can we work this out? Can we figure out if it's my child kind of thing? Is there any way to force that process?
No, with the,
I don't know, I mean, do you
somebody in
mean?
the service.
Yeah.
The mother, we've had a couple cases where, I guess the mother, female will go to DSS, alleging the soldier is the father,
Mhm.
which starts like with everything going, they keep saying that meanwhile, they contact his commander and all this stuff. But the father, I'm not, the soldier that I'm not the father, I want a paternity test.
Mhm.
But the mom won't, particularly won't cooperate. But they've already contacted the commander, and so.
So, will your commander require child support be paid if there's no order yet?
Yes.
Family
Well,
support,
family
yeah.
support, right.
So he has to start paying.
So anyway, since she's already started everything with DSS, like.
Paternity test should be done if she's going through DSS.
Yeah.
It should be, because if the father's saying, at least in my experience, I don't know if that's my child, and DSS saying we need to do a child support order against you, DSS will say, okay, let's do a paternity test. They have the right to do that paternity test.
Well, yeah, so I guess the kind of thing is that, so what I've seen is that since the Army has already ordered him to pay the family support under the Army, right, the mom's kind of backed up. So my thing
Oh,
is,
yeah.
The DSS process is not in effect when we're.
You didn't have the leverage that you had
Yeah.
before, yeah.
I don't know, never had to,
So there's no way, since, she's already opened a case, I'm talking about specifically the case that I've seen, she has gone through DSS. And since DSS has already sent out the letters and stuff, and, and so he's requested a paternity test, but the mom just stops responding. Like, there's no way, since she's already started everything,
DSS will go forward.
Yeah.
Yeah, I mean.
Unless you take it to court and get a court order in family court, but,
so she can just say, never mind, the Army's already making him pay.
yeah, see, I don't know why
I
they would make
think-
them pay before there's an order, that doesn't.
Yeah, I think it's also my experience is if the mother has gone to DSS and says, well, you know what, never mind, I don't want to do this anymore, and backs off, DSS is still going to pursue it. Because at that point, DSS, the interest is for the child, not the mom. They're representing the child. So,
Thank you, man.
does that help? I don't know if that helps.
No, I understand.
It-
If it starts, you believe it's going to continue, so we just have to figure out.
It generally will, at least because I've tried to say, okay, the mother says we don't want to do this child support order, can we stop this? And DSS says, nah, we're going to go forward because we need to protect the child.
Okay,
So,
thank you.
So what is child support? Primarily the things that you need for it covers a child's living expenses and their medical expenses. Those are the two things that's covered when somebody pays child support for a person. Both parents have equal responsibility in this state to support the child until the child reaches 18, or in some cases if the child's still in school after 18, and in some cases if it's a special needs child. The special needs child, it can go way past 18 and go past 21. It can go past, I have one client whose child's in his 30s and he's still paying child support because he's a special needs child. The three different ways you can get on child support. The public assistance program triggers an automatic referral to child support. As a parent gets TANF benefits, something like that, they automatically becomes a child support case. A parent who's not on assistance can apply through DSS themselves for child support at little or no cost. Or parents with private attorneys, they can still go to the DSS office and apply for child support. So all three ways will work. Every state has child support guidelines. South Carolina has a dual income model, so both parents' income is considered when determining how much child support is to be paid. These new guidelines went into effect in July of 2014. There is a calculator online at the DSS website that you can use to figure out child support. It probably won't be exact, but it can give you a pretty good estimate of how much child support a person would have to pay. We normally use it at our legal clinic if somebody comes in and says, I'm paying way too much child support, and we'll take the information and put it into the calculator to see if, in fact, they are paying too much child support and they need a modification, or if they'll say, well, no, you're pretty close to what you would have to pay. For one child, normal income is one child, it's $245 a month or so.
At using minimum wage as the amount. Because a lot of people that you're going to interact with are going to, their income is going to be kind of low, closer to the minimum wage. And if they don't have any kind of income at all, the child support will impute that person at minimum wage. They have to have some kind of wage. So if they want a modification and they don't have any kind of income at the time, we kind of try to make them wait until they get some kind of income to better reflect their situation, but child support will just base it on minimum wage.
And if you look at the calculator, these are the things that the calculator asks you to put in: the amount of income for each parent, the amount of time, or primarily where the child is living with which parent, any child care expenses and the mandatory work-related expenses, any hardship deductions. The person can deduct other child support they're paying for other children in the calculator, and you just plug it in, and as Mary said, impute it at minimum wage if they have no income.
Based on the imputed minimum wage, so if you're working part-time minimum wage, they'll count that
It's full-time.
as full-time.
Mhm.
So that's always the.
That's the base. That's as low as it can go.
So $7.25 an hour, or whatever.
40 hours. And it's gross. It's not net. It's gross. So all the guidelines base it on the gross income, not, well, I only take home this amount, so I should only pay this. They look at gross.
Two types of child support, and this is where you run into a lot of misunderstanding among the folks that are paying child support. I can't tell you how many people have come to us and say, my kids are 40 years old and I'm still paying child support. And that's because they're paying arrears. They're not paying ongoing child support, and a lot of it is education, trying to educate the folks on what their child support is for and what they're paying it for. Ongoing is the amount they pay on a monthly basis for their minor child. Arrears is a child support that has been incurred and they've accumulated this huge sometimes amount of money that they have to pay. I think $90,000, I think, is the most we've ever had somebody in arrears. But this is money that accumulates over time, and if you're not paying child support, then it keeps accumulating over time. Unfortunately, if you're incarcerated for not paying child support, it accumulates over the time when you're in jail for not paying child support, which absolutely makes no sense whatsoever, but that's the way it is right now.
Yeah, in South Carolina, arrears ongoing support does not stop building up if you've lost your job, if you've been incarcerated. It just keeps going.
Arrears can be owed to the custodial parent in the county where the child support office. There's two ways to deal with arrears, and they have pros and cons in both. If the custodial parent, it's owed directly to them through some kind of agreement, They have the option of eliminating some of those arrears if they want. They can go to family court and say, I don't care anymore. You can wipe out this $5,000 debt he owes. I don't want it anymore. So they can do that, but if you have somebody that's unwilling to do that, there's no negotiating. You have to go to court and modify it. You can't try to negotiate amongst them. On the other hand, if it's a DSS case, DSS, at least in our experience, is very willing to work with us and negotiate that arrears amount so that it's an amount that folks can pay and meet their obligation and not be placed in jail and still be able to live on the streets or in their own place instead of on the streets. But they can't forgive anything. If it's $5,000, it's $5,000. They can't forgive any child support, but they can negotiate, and they do frequently with our folks. Document that sets it apart is whatever kind of order it can be, and there's 4 different kinds. I've proofread this thing 100 times, but this is supposed to be medical, not medial support down there at the bottom. I missed that one. For the court order, administrative order, a voluntary agreement that has legal effect of an order, all those orders will count. Current support, medical support, and judgment for arrears should all be included in that. 2 types of child support orders you deal with, and that'll go back to the arrears and how you deal with the arrears. One is through a divorce paternity case. In this case, one parent is ordered to pay for the support of the other children, or the support of the children. The other is through a child support order through the integrated child support services. And we've gone to some of the negotiations, and you can go to the negotiations with child support in order to talk to the child support. Well, we'll talk to the child support attorney and the custodial parent and the non-custodial parent, come up with a plan that'll work for everybody and it's equitable to everybody. What we do remind people in the second type of case, actually in both cases, but if it's ordered to pay child support, you can either pay it to the parent or you pay it to the child support office, go through the court. But whatever you're ordered to do it and keep records of it, and do it so that you're following whatever the order is. I don't know how many people we've had that said, well, I don't pay child support, but I give them, I gave them money for this and I gave them money for that. Any money that's given not through this payment plan is considered a gift. It's not considered child support, so it can't be used as child support. So counsel your clients that just give it to either the mother and keep a money order or a check receipt or whatever, or give it to the child support officer, but still keep records, because we've had certainly times where they've screwed up, the courts have screwed up the record keeping, and if they have the records, they can show them that they've paid X instead of what the court says they've paid. South Carolina has jurisdiction if its original order is in South Carolina and one of the parents and the child still live in South Carolina. Because the biggest issue we deal with is out-of-state child support, or the biggest pain we deal with is out-of-state child support. And I think it's on the next slide, but certainly you see veterans. We see more veterans with out-of-state child support issues than non-veterans. When a parent lives in a different state, a child support case can be opened at the child support office where that parent lives. And the UIFSA is a law that covers that and is supposed to require all states to cooperate with each other to establish and enforce child support orders. That doesn't always happen, that cooperation. I had a case out of Tennessee that had great cooperation and got resolved. I have a case in Maryland right now that I have sent an order to modify twice. Usually, my client did. I couldn't represent him, but I filled it out for him. We sent it in, and they still haven't acknowledged that they've been received it yet. So I don't think we have any good suggestions on how to deal with out-of-state child support, other than next month, next June or next month, I'm going to a summit in Washington, D.C., talking about veterans issues and ways to have an integrated network of agencies that can work with veterans around the country. I'm hoping one of those is to deal with some kind of child support network where you can go to another state and contact somebody there and they can help you with it. Because right now, it's it's luck of the draw whether you can get it done or not. Okay, I think I covered all that. All right. How is child support enforced? There's all these remedies. We're only going to talk about the bottom three because those are the ones we see most often: driver's licenses, garnishments, and rule to show cause hearings.
Yes.
Earlier, 2 slides ago, you referenced being able to open a case where one of the parents stay. What about modification? Is it still where one of the parents stay or where the child resides?
Modification would be through the court that holds the order, the original order, that state, yeah.
Even if the child moves?
Yes, then you could, if the child and that parent, if no one is in that state anymore, then you get into jurisdictional issues and you'll have to petition the state where you want to file to take over jurisdiction of that case. So that gets a little bit more involved. You have to basically ask the original jurisdiction state to release that jurisdiction to the new state where you want to file. And then most likely, if there's no one living in that state anymore, then they're going to transfer it because they have no jurisdiction. But you have to do that first. But if the parent and the child still live in the state where the original order was, that's where you need to go. Mm-hmm.
All right. Driver's license suspensions. If you're past due in your child support, they can revoke your license, and South Carolina does it fairly frequently. Arrears have to be over $500 with no payment in 60 days in order to get your license revoked.
Which is really common.
So if you get a $5, does that count?
Nope.
Has to be a full payment.
More generally, 10% of the total arrears owed. So,
Sorry.
yeah, yeah.
Okay.
So if they can pay, if their arrears is $5,000, if they can pay $500, they can get their license back. But we do tell, sort of speaking to your question, we do tell people if they can't pay their child support, all of it, pay something. As long as they're paying something, the courts and the DMV are less likely to step in and do something. But it's those folks that just ignore it for a multitude of reasons, but ignore it anyways, and those are the ones that get their licenses revoked. Once your license is, suspension is lifted, you get your license back. You've got to make those child support payments or they'll do it again, just continuously. Garnishment is permitted for monies payable to individuals based upon remuneration for employment. And I'll differentiate that in a second. But employers are, if contacted, are required to take money out of the employee's check in order to pay child support. And actually, we encourage our clients to get garnishments because then it's taken out and they know it's taken out and they know it's getting paid.
Just a call, they know they look.
You have a form. There's a garnishment form that needs to be filled out and then sent to the employer.
Where do you get that from?
I know DSS usually hands them out, but it could very much be online.
I know you can get them at the court at the child support window where you pay your child
Yeah.
support.
The courts also have them. The courts have them. Mm-hmm. The clerks should.
We like to have them do garnishment because then it's gone from their check. Because we'll get folks that say, well, I can't afford it because I have these other bills, and we explain, well, no, child support's a bill as well that you have to pay. You don't have it's not an option for you. So if you take it just out of the equation and it comes out of your check, then it's not an issue.
And if you are representing a defendant or a client at a rule to show cause hearing, don't allow them to argue that they have other bills to pay, and that's why they can't pay their child support, because they don't really like that argument very much, because child support is a bill and you should pay that because that is one of the bills that will put you in jail if you don't pay it. So unfortunately, that's a common argument, and you sympathize with that. You understand, because you look at a person's bills and you're like, you're right, it's really tight. I don't know how you're going to pay this. But the child support really needs to come first, because that's the one that you will get punished for not paying.
What happens if the arrears and child support is so much that it does take the whole check?
You can only, by federal law, it's around 50 to 65%, depending on your marital status and stuff, or 50 to 60% of your paycheck can be taken out. So they cannot take, if you don't make enough to take out the whole amount, they can't do it. They can only take up to, I think if you're married and have other children, like 50%. But there are federal guidelines that say the maximum percentage that the employer can take out. But it can go up to 50, 60% of your check, so it can be a lot, but they can't take it all out. And that's an important point. If you're getting a garnishment and your wages aren't covering the full amount that you're ordered, you're still responsible to pay the rest of that amount. And that's when it's really appropriate to look at a modification.
We did have one client who was having his wages garnished, but they were also garnishing his bank account. So he was working for nothing, because whatever didn't go into wasn't garnished from his check went into his account, and they garnished that. So we had to get that straightened out because they were double dipping. Yeah, he was a mess.
Yeah.
But these are the things that can be garnished: wages, Social Security disability benefits, Social Security retirement benefits, VA service-connected compensation, VA retirement, workman's comp, and unemployment benefits. All those can be garnished because those are all either things you obtained through employment or you've earned somehow. Like you earned your VA service-connected compensation from serving in the military and being injured in the military. The two things that can't be garnished are SSI and non-service-connected pension, because of those are needs-based programs. That's because you have no other source of income. So you get SSI or you get service-connected pension. So those can't be garnished, but all these other things can be garnished. And if you don't pay your child support, you have a rule to show cause hearing. You have to come into the court and explain to the judge why you haven't been paying your child support. And if you don't attend the hearing, then a bench warrant's issued. And we always advise our clients, please keep the courts and DSS up to date on what your address is, because if you move and a rule to show cause hearing comes up, they'll serve you at the last place you lived, and that'll be considered service. And then when you don't show up at the hearing, then a bench warrant's issued for your arrest. So it's important to make sure the court and DSS knows where your client is at any given time. Things have changed some since the Turner v. Rogers 2011 Supreme Court case. It was a South Carolina case. The problem was that people were going to these rule to show cause hearings and having the threat of jail hold over their heads with no representation by any kind of legal counsel. So the ruling stopped short of requiring that the states require legal counsel, but they have changed the process in Charleston. I imagine Richland County is probably the same, but now if there's a rule to show cause hearing and it's a DSS case, you go in and you go in front of the DSS staff person. And when we go to those hearings, we go in front of the DSS lawyer, usually with our client. And they can explain their situation. They have to take into account the person's ability to pay, not just because they're not paying, but do they have the ability to pay. If they don't have the ability to pay, in our case, if they're applying for disability and are waiting to get a decision, either VA benefits or Social Security benefits, or if they're in the SATC program, the substance abuse treatment program at the VA, or those are the two main ones, I guess. Because SATC, you're not allowed to work while you're in a program because often income is a trigger for substance abuse. So if you're in one of those three cases, either Social Security, VA benefits, or SATC, normally they'll continue the case until that matter is resolved, until either you get your benefits or you're out of SATC and start working. So they have to take that into account. And I don't know that we've ever had somebody that we've gone in front of one of those hearings where then they've been incarcerated. We've been able to take care of those things. For private cases, though, where it's just from a divorce proceeding, those still go in front of a judge, and you have to argue those in front of a judge. But the judge, again, has to take into account your ability to pay before putting you in jail. And I've only had, I don't think you've had any, I've had one where the veteran was placed in jail for not paying child support, even though we argued the case. The issue was that he said he was these physical problems and he couldn't work and he couldn't do anything. And I argued all that, and then his wife, who was there without counsel, I said, "Judge, can I show you these Facebook posts?" And the judge said, "Yes, come up." And there was pictures of him skiing in the mountains, and there was pictures of him New Year's Eve in Savannah in a party. And the judge looked at me and said, "Mr. Hammond, do you have anything?" I said, "I got nothing." So he was, and even that case worked out to his benefit, because although he did have some problems and was getting VA, in the process of getting VA benefits, he does have those benefits now. And although it's not the greatest way to get clean and sober, his time incarcerated got him clean and sober, so that's not an issue anymore. So let me see if that's it. And now we get to switch positions, because you can press the button.
All right, I am going to start talking about modifications of child support. It's not as scary as you might think, but before you even go down the road of modification, you want to determine that it's an option for your client first. So the important thing to remember is, once a child support order is in effect, it remains that way until one of the parties, the parent or the custodial parent or non-custodial parent, petitions the court to modify. It can be done pro se, and I'll give you some links later where the packets are actually online, so someone can do it on their own. But you're here to help as an attorney, so it's always best if they have representation, so they better understand it. In South Carolina, in order to request a modification, you have to prove that there's a substantial change in circumstances. And these are some options that indicate what a substantial change in circumstances is: an increase or decrease in earnings, change in custody or the amount of time spent with the child, because the child support guidelines look at the amount of overnights that the parent has, a change in any other factor that would affect child support, which could actually be the presence of another child. If the person paying child support has a new child that they're supporting, then that will factor into the guidelines. It's very important to remember that when you're talking about a decrease in earnings, that a loss of job must be involuntary to be considered a substantial change in circumstances. You can't quit your job because you didn't like it and then file for a modification because your income has decreased. It just doesn't work like that. It has to be involuntary. Medical condition, injury or disability, like if you're applying for disability, or you can't work like you used to. A lot of times the judges and DSS attorneys will require a physician's report, which is a form that you can get also that a doctor will have to fill out saying this person has been injured and cannot work right now, and that's taken into consideration. As I said, it does not automatically change when changes in employment income. Actually, I'm going to go right back, talk about emancipation. The child must be emancipated. In South Carolina, to modify your child support based on emancipation, which essentially means to terminate the ongoing child support, a parent must petition the court to do that. Unless you have a court order that says, upon this date, when the child turns 18 or graduates high school, court shall automatically terminate child support, you must petition and ask the court to terminate the child support, or the ongoing will just continue. We see that a lot of times. I'm working with a client now who the child is 21 and they're still paying ongoing because no one informed the court. And the mother who's receiving the child support is not going to say, hey, stop paying me. So you have to petition the court. And emancipated in South Carolina is 18 years old or 19 if you're still in high school. And then it would become, which is the later of the date, 18 or graduation from high school. That's when emancipation occurs. So it doesn't automatically change with changes in employment income, does not automatically stop when employment ends, does not automatically change when the child is 18 or emancipated, and you must request it. Huge tip, act promptly, because the court can only modify an order from the date of the filing. There is no retroactive modification. So if you have not told the court that, my child was emancipated 4 years ago, you should go back and change my arrears to account for that, they generally will not, because it's no retroactive modification. It's only to the date that you filed that action.
In a situation where DSS is not collecting the child support, how do you terminate the child support order?
you request to modify through the court, and you request to modify, or request to terminate based on emancipation. You have to file a motion.
As far as the special needs and the mom saying my child's disabled, just don't need to pay, is that originally written in the initial order, or who determines that child actually is disabled? Because we have had some of those where they're insisting that it still pays because of a disability, but who says that child's disabled? What are we relying on?
In the case I had, they were looking, the child was still getting SSI benefits.
Disability.
So that they used the fact that the federal government says he's disabled, so he's disabled.
Mm-hmm. Yeah.
I guess you could go to court and argue, ask for a doctor's examination to see.
Well, we have this guy who's going in his 30s or something, and his dad was still paying child support for the mom. I was living on his own, there's no kids. Criminal records, like, he's in and out of prison, and the mom was saying that she needed child support.
Well, the other issue.
Yeah.
The other issue there too is the child's not living with the mother, so the child's emancipated at that point.
He was not going, the problem was he was not going to speak out against his mother. Like,
I would prove through
I know.
addresses and stuff. I don't know. That's crazy. Yeah. Yeah. Mm-hmm. And emancipated can mean, you can be 16 and be emancipated. You just have to move out of the home of the custodial parent. So if that child is not living with the custodial parent or the parent that is receiving the child support, you want to let the court know that, because that parent should not be receiving child support if they're actually not supporting that child.
Even if they're placed in a special home, or they have to place them somewhere?
Now that I don't know.
Yeah, I don't know how that would work.
Is it usually that kind of placement Medicaid would cover it?
You would
so
have,
it
yeah,
so
or if the parent was having to pay for that placement, then that would be maybe a separate issue. As I mentioned, all forms that you would need for a modification can be found at sccourts.org. There's a modification packet. It's pretty self-explanatory, easier for us as attorneys to understand versus, your average citizen. So it's really helpful to kind of go through that packet with them if you need to, or modifiedchildsupport.sc.com.
I think every state has that same, we use it from other states, but also you just go online and you can usually get the
Modification
packet.
packets. A lot of states have it, so it's very helpful. Some other considerations with modifications. Visitation. One of the number one things we hear is, well, I'm not paying child support because the mother will not let me see my child. She is not honoring visitation. I've tried, and so I am not paying. Well, you still have to, because child support and visitation are two separate issues. Same as the parent who's receiving the child support. You can't withhold visitation for non-payment of child support because it's two separate issues. Unfortunately for us, we see that a lot, that you have a person paying child support for a child they haven't seen since the child was born. And it's hard for us to help with those matters because visitation gets a little bit more detailed under the law, because you have the factors, you look at the best interest of the child, and we just don't have the capabilities and the time to handle visitation matters. So it's always helpful if you want to help the person holistically and help them with their visitation, what you're doing, or you find an attorney that will be willing to help you, which is very hard to do, we have found. But it is two separate obligations, so you kind of have to separate the two. Unfortunately, termination of parental rights, termination of the non-custodial parent's rights in most cases does not relieve the obligation to pay child support. The court can still order child support.
And the only time I think it's changed is if it's terminated so that the custodial parent is remarried and that father wants to adopt the child, then I think and we've had a case there where they then relieve the father of child support payments, but that was the only one I know of.
Is that for ongoing support or just arrears? Or
Ongoing
arrears
from
makes sense, but ongoing support, that doesn't really make sense.
I'm sorry.
if for the termination of parental rights, if a parent's rights are terminated, would they still have to pay the ongoing support?
No, they wouldn't have to pay ongoing. They
Just
would
the-
probably have to pay arrears
the
if they owed
arrears.
money.
Mhm.
Yeah.
So having an attorney with modification or child support, it is not required, but it is definitely beneficial for the client, especially when working with the veterans in any kind of veteran clinic. You need to, attorneys can be an advocate for the client. They can be crucial in veteran outreach, figuring out, services and stuff that would be helpful for the veteran. And then you provide representation in contested or complex matters. So to what extent do the child support issues facing veterans require a lawyer's intervention? The number one thing we find that is helpful for the veterans to have lawyers for is to help develop a trust between the veteran and the child support professionals. When a veteran comes to you, a lot of times he or she has already been through the court. They have already been in front of a judge at some point for not paying, and they're scared because they have developed a mistrust of the system because they have been thrown in jail for not paying child support. They have not really been listened to. The judge didn't actually determine their ability to pay, unfortunately, when they should have, despite their pleas. People get in front of a judge and aren't familiar with that situation, and you can freeze, and you don't know what to say. And so veterans have not really been able to say, well, I can't pay because of this, or they'll say, I have other bills, and there they go to jail, unfortunately. Some judges, more than others, will incarcerate. But it helps for attorneys to come in to help develop that trust. You help them understand the law. There's a lot of clarifications that need to be had. You have to talk to them about the child support and the custody visitation issue and how it is separate, and let them know that their child support obligation must continue despite the lack of visitation. You have to inform them on how you actually calculate child support, what factors are important, how to modify, and the concept of arrears. As Jeff mentioned earlier, they don't understand that arrears are just that, arrears that are still enforced.
Do you see a lot of it with active bench warrants coming into the clinic, and then how do you resolve the bench warrant?
We do. We have people come to us and say, I think there's a bench warrant, can you find out for me? Or I have a bench warrant and I'm not turning myself in. Well, we always advise that you do need to turn yourself in, and we arrange for them, and at least in Charleston County, we know that bench warrant hearings are at 2 p.m. on Wednesdays. So if you turn yourself in on Tuesday night, you're only going to spend one night in jail, and then you will go in front of a judge the next day, and you can arrange as the attorney to be there to represent the person and explain the situation, and just really hope that there's a good argument. But we do see that, and we have to, advise it's probably best that you do turn yourself in, because if you don't, you risk getting stopped and put in jail, and then you don't have an attorney, because if you can't get in touch with us, we're not going to be there to help you. So it's best to coordinate with us in turning yourself in so that we can be there to represent the person.
The bench warrant's almost always for failure to appear.
Yeah.
And it gives us a chance, and so the judge hasn't heard their side of the story, so it gives us a chance to go with them to court and give their side of the story.
Yep.
Yeah, we have officers in the auditorium with us. You can always tell these guys because they're wearing like these, and they're like standing around, like looking away from the police.
Yeah. They don't know unless they stop you, and
Memorize everybody's names.
yeah. And you're not going to have people that are going to be willing to turn themselves in. I mean, I don't know how many times I've worked with a client and said, yes, you have a bench warrant, can you turn yourself in on this day, and I'll be there on Wednesday. Yeah, sure, no problem. Then they call you the day they're supposed to turn themselves in and say, I can't do it because I've got to work out this thing first, and I haven't heard from them since. So at least you've advised them they have a bench warrant and what they should do. It's on them at that point. So when you're addressing child support issues, especially with veterans, it's more of a collaborative and a holistic approach, meaning you collaborate with many different providers and different parties, meaning DSS, the prosecutors, the judges, and holistically you kind of look at the whole situation with the veteran and what's going on and what can we do to help this person with child support and outside of child support. That's more of kind of how we handle things. Now, if you're just doing it in the clinic, you might just be doing modification and that's it. But we find that when our veterans come to us, they don't always just have one issue. And I'll talk about that in an example later. But the challenges that you have when, doing this is it's hard to find lawyers that actually understand veterans and veterans issues, along with the child support issues at the same time. It's hard to find the training and support needed. So this is actually great that you're doing this. And then dealing with out-of-state child support matters, it can be a nightmare, and it can be very frustrating because, as Jeff mentioned, in doing this Maryland modification, I've had no success with Maryland as well. It's a roadblock, and you have to unfortunately tell a veteran, look, I don't know what else to tell you. You might just need to go to court in Maryland and petition yourself because we've tried. So it's really difficult. There is a puzzle, and it involves a lot of players. And, the lawyers are one piece of that puzzle. Other pieces would be the DSS attorneys, DSS caseworkers, judges, service providers, out-of-state child support agencies, people that you will work with. In this case, it is so important to develop relationships with these people and see it not as a me against you kind of thing all the time, but what can we do together to help in this epidemic? We find, as Jeff mentioned, homelessness of veterans, child support is one of the top, top 3 reasons why they're homeless, because they have all this child support and they can't afford anything else. So if we all work together to address the issue, we can affect and help other issues such as the homelessness factor. It takes a group effort, and we all have an opportunity to make a real difference. Here's some websites that are just helpful for you. Do you want to talk about it?
The Commission on Homelessness and Poverty website is probably the best one because it explains the Veterans Child Support Initiative, which Mary's going to talk about next. But it also has a lot of new things about a anti-poverty initiative that's been started through the Commission on Homelessness and Poverty. They have blueprints. There's going to be 10, I think. I think we've got 8 of those out, dealing with various issues like employment issues and education issues and things that you can look at that I think are going to be very helpful. The one on criminalization of homelessness is probably the best one, I think. I wrote that one. But I was on the commission. I've rotated off the commission, but I still am a liaison with the commission, so I'm still part of the process with them. So they do have a lot of good stuff about child support issues, and actually this initiative that Mary's going to talk about, I think, next, right? Or close to next?
Yep,
Okay.
next. So the 180 Place Veterans Child Support Initiative. The Child Support Initiative was modeled on the ABA, SAMHSA, VA pilot programs. Initially, there were 9 pilot sites across the country where they decided, let's do this child support initiative that's going to help address child support issues with veterans and maybe, come to resolution or all the chaos that's going on. So they created 9 pilot sites, and because Jeff found out about it because he was with the commission, said, we're going to do this as well, even though we're not a pilot site. And so we became the first non-pilot site to do the Veterans Child Support Initiative. And what the Veterans Child Support Initiative is it is a way to address the child support issues of veterans in a manner that will allow the veteran to stay connected to ongoing rehabilitation and support services, which essentially means if the veteran is currently working to rehabilitate himself or herself, whether in finding a job, whether in applying for disability or going through substance abuse treatment program, then through the initiative and the collaboration with the judges and the DSS attorneys and other attorneys, we were able to say, as Jeff mentioned before, hey, while my client is applying for disability because he or she cannot work, or while they're doing a treatment, please don't throw them in jail. Please don't punish them for not paying their child support. There's a reason they can't pay it, and we are trying to work on fixing that problem so that they can get some income and regain their self-sufficiency and start paying their child support obligation again. And luckily, we have developed great relationships in Charleston County, Berkeley County. I'm not so sure about Dorchester County yet. but they will hear us out and allow a continuance of that rule to show cause for 3 to 6 months later, depending the outcome of what's going on. Now, if you're a veteran, unfortunately, it's denied disability benefits, they don't have an excuse at that point. They've got to start paying their support or fine at work. But while they're in process of applying for disability or substance abuse treatment, the courts are pretty lenient in letting them continue that, because you want to rehabilitate the person, because the whole point is to get that child support. And if they can't work, or if they have a substance abuse issue that's stopping them from working and handling their obligations, you want to rehabilitate them to get them back on track.
Your point person's your VJF, identifying those people, right?
At the VA,
Mostly,
yeah.
I think.
And
mostly
judges.
Yeah, we're getting a lot of referrals from the judges.
Yeah.
Saying, when we don't know about the case and they come in for the judge will say, go see Jeff and Mary at the shelter, and they'll take the case in.
Yeah.
But we get a lot of word of mouth from other veterans who tell people, go see them, but they'll take care of it.
Yeah. So it's the initiative is staffed by us, the Homeless Justice Project staffed, the VGO, the Veterans Justice Outreach Coordinator, and an attorney from Child Support and DSS, pro bono attorneys, and law students. So it's kind of a group effort.
Oh, there it is.
Yep. So veterans can be referred by the VGO, VJO, their case manager, 180 place case managers, other veterans, or family court judges. So if a judge sends someone to you, you don't say no. You help them. And that's actually a good thing, because that judge is recognizing that there's an issue that needs to be addressed. And they aren't looking at your client as just someone who's just not paying. They're looking at there may be an option to help fix and help this person. So that's a really positive thing. So we work to renegotiate existing child support orders through modifying the ongoing, modifying arrears, removing holds on driver's license, and representing the veterans at the rule to show cause hearings and bench warrant hearings, as I mentioned before. The way we kind of do business, and this is how we kind of handle our child support cases, is these are just some examples of things that we do. A lot of these matters can fortunately be taken care of through emails to your local child support office. As you mentioned, you started developing a great relationship with the Richland County DSS attorney. I always advise creating relationships with them, because we can just shoot an email to our local DSS attorney and say, I have so-and-so that's come to clinic. He says, he thinks he has a bench warrant and he doesn't really remember how much he owes in child support or what he has to pay. And you're going to find that a lot. The veteran does not know how much they're supposed to pay in child support. They don't remember. Or when they got the order, they weren't there and they've never even paid attention. So we just shoot an email and say, can you tell us everything you know about this person? And they'll tell us how much they're supposed to pay, if there's a bench warrant, what their arrears are, anything that could be helpful for you. And then if there is no custodial parent involved, or the custodial parent, is in another state or something, then sometimes you can even work out negotiations to modify through email and consent orders, and just get a consent order. Because if all the money is owed to DSS and there's no custodial parent really involved anymore, then they can do a consent order with you through email, and then you sign the order and send it into the court, and you don't even have to step foot in court. It's awesome. It saves so much time and headache. You can also go to negotiation conferences at the child support office. A lot of times this is where child support will be set. You have the DSS attorney, you'll have you, and you'll have the non-custodial parent and the custodial parent. And you just negotiate. And really it's a simple negotiation, because you just put in the numbers in the child support guidelines. So there's not a whole lot of arguing unless you have a parent that's withholding financial information. And that has happened before. The other parent will say, no, I know you make more than that because of this or that. And then that's up to the DSS attorney to figure out what the income really is. And they can easily find that through tax records and stuff. We complete and file pleadings for the parent through the court if necessary, represent them at modification and rule to show cause hearings, help with out-of-state pleadings if we can. And then we also provide a holistic approach, so we help them on other issues. If they say they can't pay child support, support because they haven't been able to work for 5 years, we inquire why that is. And if it's because they've been injured or they have disability, then we look at filing for a disability claim as well. So we kind of do a little bit of everything. We're going to talk about a few frequently asked questions. And we kind of touched on some of these, but these are things that people will have. Can a father be responsible for a child he did not know about? What do you think? Yep. Even if the relationship ended before the mother even knew she was pregnant, mother never told him she was pregnant, or the mother does not want him to spend time with the child, he is responsible if he is legally established as the father. And if you're unsure, get a paternity test. My client said he or she did not know about the child support order. Is that possible? Yes, it is. You do have to be served and get notice, but, you know, they allow personal service by sheriff or process server or certified mail. So, you know, if your address has changed and you didn't let people know, then there's a problem. And many individuals ignore those court summons out of potential, you know, out of fear. You know, they don't know what's going to happen. They don't just want to show up. So, yeah, you can definitely have a support order and not know about it if you don't show up to a hearing. My client says he does not see the kids. Does he still have to pay support? Yes, I already touched on that. Although there is an emotional connection between spending time with the child and paying for that child, it's two separate obligations under the law. Will the child support agency enforce the visitation of my client's support order? Correct. No. They only deal with child support, not visitation issues, unfortunately. Some state child support agencies help establish parenting time plans with the support order. However, they will not enforce a parenting plan or visitation order. I'm just going to take a couple seconds just to kind of tell you guys about a little success story to let you know that what you do is important and it will help somebody. Although I will be upfront, this case actually did not involve child support, but it came to us through the Child Support Initiative because for some reason the courts and attorneys thought it was a child support case, though it was clearly an alimony case if you actually looked into the case. Our client was referred to us through the VGO, the Veterans Justice Outreach Coordinator at the VA. She brought our client to us. He had been married in 1989 and then separated from his wife in 1998. And since then, he had been paying spousal support from 1998 to the present. However, upon research, he was paying spousal support under a temporary order. And that happened because in 1998, an order for divorce or a complaint for divorce was filed. However, in 99, it was struck from the pending roster for inaction. A final hearing was never requested, so the clerk of court said, okay, we're just going to dispose of this case because there's been no resolution. However, there was a temporary order that was issued in that case that by virtue of the case being struck did not address the temporary order. It still just kind of hung around out there. So in 2001, our client's wife finally files for divorce again and says, no, really, we're going to do it this time. Gets divorced. Divorce is granted in 2002. Final order does not include order of alimony. It does not include anything, and it doesn't even reference the temporary order that's still out there. So you still have a temporary order that by virtue of the name is supposed to be temporary being enforced against this guy. He was supposed to pay, I think, $700 a month in alimony, and he had been enforced. So since 2002, despite the final order that did not even order alimony, he had been in and out of court on rule to show causes for failure to pay that support. And the reason why it came to us as a child support issue is because upon reading the notes from all these rule to show causes, the judges were saying it was child support. And despite our client saying, no, I don't even have a child, he doesn't even have a child, they were still enforcing it as child support. So it kind of was an example of the judges not really listening to the client. And so despite our client saying, I don't even have a child and I can't work because of this, or my income has changed, they said, some judges said, I'm sorry, and put him in jail. He spent how many, approximately 4 years?
Okay.
Is it on the next slide? Yeah, okay, so I don't think we put it in the slide, but he spent approximately from 1998 until I think 2014 when he came to us, over the period of time, 4 years in jail on this, despite his inability to pay because his health was deteriorating. His work hours were cut to 2 days a week, and he could no longer afford his apartment. He could no longer pay what he was paying, and he basically had it. So he came to us because he found out about the Veterans Child Support Initiative. Although he wasn't paying child support, he was being treated as he was. So he came to us, and our research discovered the glitch and the temporary order. And so what we did was we decided we have got to end this. Like, there's no reason he should be paying under a temporary order. So we did some research, got creative. We also found the wife, or the ex-wife, and found that she had been cohabitating with somebody since 2004. In South Carolina, if you are ordered alimony payments to somebody, if that person who is receiving that money is cohabitating in a romantic relationship with somebody for 90 days or more, that alimony can be terminated. It can be stopped. So we filed a motion based on multiple things, on cohabitation, on the fact that it was inequitable to enforce this temporary order, and then at the very least, if the judge did not grant any relief, at least modify what he is paying, because he cannot afford to pay $700 a month anymore. So first hearing, it was my first big case. I was really proud, to write this long brief, this long memo to support my motion. And I submitted the motion and the memo, and we go into court, and the judge doesn't even have my memo. He doesn't even have the file. The stuff he has in the file isn't even helpful. So nothing really happened at that motion hearing. Mainly because when the wife saw all of us walk up, there was 2 attorneys, legal assistant, and a law student that walked in. So we kind of had a posse with him. She freaked out and called the attorney that originally represented her back in 2001. And although, generally you would argue that would not be enough, the judge said, okay, well, since she has the attorney on the phone and the attorney says they're going to represent her now, I'm going to continue this case. And basically he said it was a complicated matter, which it was, although he did indicate that he agreed with our argument, so it gave us a little confidence moving forward, so we didn't stop. So we filed the motion again, and at the second hearing, when the other attorney was there, we were able to negotiate and terminate retroactively, because with, I think, with alimony, you might be able to retroactively terminate, but we were able to negotiate retroactive termination back to 2002 when the final order of divorce was instituted. And we took his arrears, which had totaled $95,000, down to $1,951. So he paid off his arrears. He was good to go. We also helped him obtain Social Security disability. Unfortunately, found out he needed a lung transplant. He was that sick. But hey, he's on disability now, his alimony is gone, and he's able to live a life without the fear of incarceration and being harassed by the courts anymore for this support order that should never even have continued past 2002. Anyone have any questions? That's all we have. So if you have any questions, here's our contact information. Just let us know. We are very accessible. If you need to email or call, we'll be happy to answer any questions or just kind of give you some advice on what we've seen and what we've done.